please subscribe and don't forget to press the bell icon to get notified whenever we upload a new video.
In interim relief for incumbent telecom operators, the Telecom Appellate Tribunal, or the TDSAT, has stayed the enforcement of regulator TRAI's order on reporting requirements and the new definition for ascertaining significant market power. That's in the context of predatory pricing. Now, TDSAT has also directed that no penalties be levied until further orders. However, in its order, the Appellate Tribunal has allowed TRAI to collect details of segmented discounts or concessions for the purpose of analysis. Ashmit Kumar, who's been tracking the matter in the TDSAT, joins us now with the details. Ashmit, a breather for the incumbent telecom operators.
Indeed, this was the exact relief that incumbent telcos, the petitioners, to be specific, were seeking. The petitioners, of course, Bharti and Idea at this stage. And both those petitioners essentially raised two grounds. One is the reporting requirements. The contention of the telcos, the incumbent telcos, essentially was that the reporting mechanism, the way it has been envisaged under the current, the new set of predatory pricing rules, is that individual discounts to individual customers will also have to be reported as a separate tariff plan. This was the concern expressed. This was the first concern. The second, of course, was the definition of the SMP, how various aspects have been excluded as a part of computation of SMP, a significant market player, and that was the second reason for concern. Now, the TDSAT has taken cognizance of both these concerns. In fact, it also records as a part of the order that the current predatory pricing rules are a departure from the IUC regulations, and that this is expected to have, this change is likely to have far-reaching ramifications. So in light of that, the interim relief that was sought and has now been given is that the clauses of the predatory pricing order with respect to reporting mechanism as well as with respect to SMP have been stayed. Not just that, the TDSAT has gone a step further and has issued an explicit direction that as far as the levy of penalties is concerned, that will not be the case. TRAI will not be levying any penalties until further directions from the TDSAT. One caveat, however, important to mention here is that even though the reporting mechanism has been stayed, the TDSAT has provided as a part of the order that as far as segmented discounts are concerned, that is something the TRAI can still seek data on. So clearly, with that caveat, clearly the interim relief has been given, so much needed relief coming in as far as the incumbent telcos are concerned and as far as their case against predatory pricing. Of course, as far as the road forward is concerned, important to keep in mind that TDSAT is the appellate tribunal. There is still legal remedy available to the TRAI in the form of the apex court. So that appeal against this interim order, that option, that remedy is still available to them. Whether or not they choose to exercise it, we'll find out in the days to come. But for now, relief coming in for the incumbent telcos.
Ashmit, appreciate you joining us to take us through the details of the order that's come in from the TDSAT. Joining us now is the former TRAI Chairman Rahul Kullar, and also with us Rajan Matthew, Director General of the Cellular Operators Association of India. Mr. Kullar, if I may start by asking you, sir, I would imagine that the TDSAT order doesn't surprise you because this is what you have been at least writing about. You have believed that, that the TRAI's predatory pricing order would not stand legal scrutiny. So you wouldn't be surprised by this order?
Not at all. I had said so sort of very clearly in an article I wrote for the Business Standard more than a month ago. So I'm not surprised that what they have done. I suspect that the final order will look at some other dimensions apart from the interim stay, and then you're likely to see more fireworks.
Before I get to the other dimensions that you believe the final order would look at, you know, from a consumer's perspective, from a layperson's perspective, Mr. Kullar, you know, they would think that one would imagine that regulation changes over time. If the IUC regulation was notified in 2003, we're now in 2018. Why is it wrong that the regulatory regime changes, unless it is, of course, bad in law? How would you explain the predatory pricing order? And because the TDSAT order, while saying that the TRAI order will have a significant impact and ramifications, stops short of actually spelling those out. What do you think will be the implications if the predatory pricing order continues?
Well, look, all regulation is timed and it evolves over time. So even the IUC regulation, which you're referring to, it has changed over time, and the new orders that are issued from time to time, even on IUC, change with the times. It's not as if they stand still. So even the one that was issued in 2015, is different from what preceded it. So it's not that regulation is cast in stone. The second point is to ask yourself the following thing. While it's fine to change regulations to adjust to the time, how do you justify that you compel everybody who is incumbent to provide details of every discount and every segmented offer when for the last so many years, while times have changed and while competition is taking place, you have never insisted on it. So what's the justification? Second, more importantly...
But on that point, Mr. Khullar, sorry if I interrupt you. Just on that limited point, because the order very clearly says that respondents will be entitled to ask for details of segmented discounts, but no penalty will be levied.
No, there's a distinction, Shireen. The distinction is this. What the TDSAT has also said is that since you have placed a cap on the number of tariff orders at 25, and you treat every discount and tariff segmented offer as a separate tariff, you will obviously be in breach of the 25 ceiling cap. This is This is an absurdity in that order. So obviously they have caught it and they have said that this is not legally sustainable, which is why they have gone further to say that you cannot impose penalty. So you can fine. You want to get information on segmented offers, fine and dandy. But merely because it breaches the 25 cap that you yourself have stipulated, that is no basis for a penalty. What the court is essentially asking is, one, why did you have to make each segmented offer and each discount a separate tariff plan? And the TRAI is on very weak ground over there. Second, once that's defeated, then the rest doesn't stand. The rest of it doesn't stand. So what can you do?
Okay.
So my guess is that,
Mr. Khullar.
Yeah. Hello?
I just wanted to get your opinion on the argument that it was made by the government and the ASG in court, because again, that's what consumers are going to ask as well, because the government and the TRAI's proposal in this matter has been that this order is in the interest of the consumer, and this order will force the required principles of transparency, which will ensure non-discrimination amongst customers of the same class. So how do you respond to the fact that do you believe that this is or is not in consumer interest?
Short answer, consumer interest is more than safeguarded by existing competition. Meaning, are you seriously trying to convince me as a consumer that merely by this order my interest is being protected? Absurd. It's the fact that there's a rival company which is willing to offer lower prices and has compelled over the last 1.5 years for data prices to go down. That is what is ensuring safety to the consumer, not any order issued by TRAI.
Right. You said that you believe the final order will look at some other dimensions beyond just the reporting requirement, as well as the definition of market share, which stands changed post the predatory pricing order. What dimensions do you believe we will now see being focused on?
Well, I don't know what I don't know what they're going to argue in court, what the lawyers do, but at some point of time, issues are going to arise that, was it really necessary for TRAI to issue this order when the Competition Commission already has a predatory pricing order? And in fact, that predatory pricing is exclusively the preserve of the Competition Commission. Why is the TRAI going into this? Second, irrespective of anything else, on merits, one of the key principles which Justice Joseph and Justice Nariman laid down in that earlier case in which TRAI got clobbered was that, look, you must at all times have a balance of interest. You must take into account the balance of consumer interest and the balance of producer interest. Equally, you must also take into account the balance across producer interests. You can't be sort of tilted in one direction. Now, these are issues that are not going to go away. So at some point, these will come up. And should this be escalated to the Supreme Court?
Which I'm sure it will be, sir.
Well, then let's see what happens in the Supreme Court. That's all I can say. But my own reading of what is happening is that I think it was unnecessary to issue the order. It's not really required. You already had fair competition. Prices were falling. Where was the need for all this? Rather futile, if you ask me. But anyway, that's my opinion.
Okay. Futile and unnecessary on the part of the TRAI is what you're saying, Mr. Kuller. Let me end by asking you, sir, we're on the cusp of seeing the government unveil the new Telecom Policy 2018. What is it that you believe should be the pillars driving that?
Well, I'm very cynical about policies because we saw an NTP 12, nothing happened now, and you're announcing a policy virtually at the end of the tenure of the incumbent government. So I don't know how that policy is going to actually go forward and what they're going to build into it. For all you know, it will be like NTP 12, motherhood and apple pie statements. So I'm not linking too much hope on it. I think the important thing from a public policy perspective is only two things. One, you have still, after 25 years, not reached out to so many people. There are 50,000 villages which are uncovered, which don't even have 2G, forget 3G and 4G. So what are you doing for them? And second, do you really think, what is the assurance that you're going to be able to provide affordable pricing and good governance delivery through the telecom network, something which we've been talking about for the last 8 years. First they had the UPA government, now this government, all about digital India, etc., etc. Now, where is the meat on that bone? And unless you put flesh on both these bones, the rest of the policy is very, to my mind, academic.
Okay, so you're saying that you don't, you're not going to spend too much of your time on the NTP 18 because it's likely to be motherhood and apple pie statements. But I'll end then by asking you, Mr. Kuller, what concerns you most about the current telecom landscape? We do have financial stress that we're seeing across the board in the sector. We've just seen Bharti Airtel announce its numbers today, and that's fairly evident in those numbers. You've got this Digital India mission, you've got the broadband Bharat aspiration and so on and so forth. You've got 5G aspirations, but where is all of that investment going to come in from? What concerns you most about the state of Indian telecom today?
Well, you've actually encapsulated everything I've been saying for the last 1.5 years, that ultimately public policy and regulatory policy must take into account India-specific problems and how you're going to solve those India-specific problems. Now, one of the biggest problems staring in the face is the financial distress. Now, how long can the government and the regulator be blind to that and plan policy? This is why I'm saying it's no point talking about telecom policy till you talk about these fundamentals first, and nobody seems to be interested in doing that. So you can make all these highfalutin plans for, digital India, good governance, e-governance, la-di-da. But if there is no money or no resources backing it, you have a problem. And government of all people must be conscious of the fact that given the fiscal crunch they are in, they cannot afford it. So the money has to come from the private sector. But where is it going to come from? An indebted private sector that is barely making any EBITDA margin to plow back any investment. That's the big problem. And nobody seems to be talking about it.
Well, Mr. Kuller, we'll have to leave it there. Appreciate you joining us here on CNBC TV18 with your thoughts on the order that's coming from the TDSAT, as well as your assessment of the state of India's telecom sector. Thanks very much for your time, sir. Let me go across now to Rajan Matthew for a quick comment from the COAI. Rajan, relief coming in for incumbent telcos. I would imagine, as I just pointed out, that this is now going to move to a higher court. But in the interim, what does this mean now for companies, the incumbents?
So, Shireen, yes, I think the incumbent operators will heave a sigh of relief on the particular order of the TDSAT. And again, of course, there might be this pressure to move over to the Supreme Court to ask for relief from this particular opinion. But, again, when we talk about ease of doing business, the government has been trying to minimize this whole issue of appellate processes and continuous appeals and try and get quick resolution to these matters. So I think it's in the best interest of the industry and all of the players to try and get this thing resolved in an appropriate manner, other than through judicial proceedings and processes, which are both indefinite and uncertain. And so that, I think, should be the way forward.
Do you see hope for that, Rajan?
Yes, I do.
Do you see hope for that?
Yes, Shireen, when you looked at the situation of the industry, around about 2001 or so, a very active government decided to sit down with the industry and say, guys, let's sit across the table. We had similar situations, enormous amount of litigation, all kinds of penalties, the industry in distress. And, a very dynamic prime minister at that time, Mr. Vajpayee, sat down, asked his administration to sit down and resolve these matters across the table, as opposed to endless litigation and counter-litigation. I think this is the way forward for the industry and for the government. I think it's time come, as Dr. Kullar said, look, we've got to look at fresh initiatives and alternatives.
So you want the government to facilitate a truce?
Absolutely. I think this is the way. Otherwise, it's just a waste of money, time, resources, and ultimately it serves nobody good. It doesn't serve the interest of the consumer. It does not serve the interest of the industry. I think it's time to come down and sit down together and say, how do we resolve this imbroglio that's been going on for the last several years?
Gopal and Rajan Matthew hoping that this doesn't have to move to a higher court, which I'm sure it will. But on the face of it, what does the TDSAT order now mean for incumbents, and what's the road ahead?
Well, two things. The appeal against the order of the regulator has been admitted, which means it's seriously under challenge. The correctness of that order is going to be tested. Second, they've granted a stay on SMP and the reporting requirement, because through this route of the reporting requirement, the entire regime was changed, essentially dealing with marketing and business issues which are not within the purview of the regulator. And third, in the interim, as you've already discussed, some kind of information sharing, but no action to be taken. So I think the roadmap now is to have this matter heard and decided, because it raises very, very important issues. And I heard you talk about consumer interest. Imagine if you have an order which actually does away with discounts and benefits. On the face of it, it's against consumer interest. Marketing freedom, flexibility, choice are all sine qua non in every sector. So this is against the basic grain of thinking, both of business practices and regulatory thinking. And essentially, as I see it, it's nothing but a bridge to facilitate migration of subscribers from A, B, and C to a particular D. Because you're saying that to retain subscribers and customers, you can't offer discounts and benefits, and if you cross 25, that's the cap. So I think this is something which requires a thorough probe by the adjudicatory body. It's changed the entire landscape. It has prevailed for 15 years. There's no strong rational basis to the whole thing. So this is something, as you said, the roadmap. We require certainty on these issues, and a quick decision will, I think, enable that.
Okay, certainly, and a quick decision. But Gopal, let me end then by asking you about what do you see as being the most significant implications of this order? I mean, you've been arguing about it at the TDSAT against the TRAI's order for your client. What do you see as being the most significant impact on account of the pricing order?
I think the most significant thing is that the court has decided that, look, this requires a proper, thorough examination and scrutiny. It has to be tested on constitutional and legal principles. It has to be tested on the approach taken by the regulator. And in the meantime, they've said, please hold your hands. Don't proceed on the basis of this decision that you've taken. I think that's a very good message, that if you come up with something which is totally wrong, then the courts do interfere and say, but till we examine, don't give effect and implement it. I think that's the strong message, that judicial scrutiny, a very valuable right, is hale, hearty, and breathing well.
All right, Gopal Jain, we'll have to leave it there. Appreciate you joining us there. Gopal Jain, the counsel for Bharti Airtel, who argued at the TDSAT now staying the reporting requirements, as well as the penalties associated with that, and also the definition of significant market share that were changed on account of the TRAI's predatory pricing order. With that, it is time for us to wrap up this CNBC TV18 special, but don't go anywhere. We've got more coming up right after this break.